Well, it's past 6 o'clock, and the ad said we were going to start at 6, so sorry for the delay. Some technical difficulties that we're trying to handle here. So I call this meeting to order. This is a hearing of the Baldwin Board of Appeals. This is a hearing that was requested by Jennifer and Michael Marsilio. This has to do with 73 Sand Pond Road in East Baldwin, which is on map 14, lot 33A. And the original application request was for administrative appeal. And the variance portion, setback. When we had our last meeting, we were advised by both the town attorney as well as the Marsilio's attorney that the portion with regards to administrative appeal, that we ignore it or pass over it, basically being a moot point, because of the remediation that took place down there, like I said, made it moot. So what the board did is did a vote to pass over that, or what we will do tonight is we will address that when the board goes into deliberation. That will be part of our deliberation. What I'd ask you to do, unless you have emergency situations, if you could turn off your cell phones or any electronic devices that might make some noise or whatever distracting us through this meeting. We've got a lot to cover, everyone who's attended this evening who wishes to speak will be given an opportunity to speak. The procedure that I'd like to follow is stand and give your name, and if you're a resident, a non-resident, a budding property owner, concerned citizen, or legal counsel, limit your remarks, please, and have them be pertinent to what we're trying to discuss here tonight. And I would ask some civility and try and keep emotions in check. If the party is speaking and you have a question, I would ask you to go through the chair to have them clarify it. That way we don't have bantering going on back and forth. So I appreciate that. At the October 30th meeting, for the completeness and the acceptance of the application, it was recommended by the town legal counsel, as well as I say, the Marsilio's attorney, that the administrative portion be bypassed. So what I'd like to do at this point is put that before the board, that the portion of the application for variance that makes reference to administrative appeal, we'd like to, at this point, bypass that and address it at the end of the meeting. So I'd like to hear a motion and a second.
These might be too close together. One needs to be muted. Oh, okay.
I move that we bypass the administrative appeal.
Do I hear a second?
Second.
Those in favor? Okay, so at this point, we have bypassed that, and we're going to go right to the portion of the application that asks for the variance. Variance would be a minimum variance in terms of setback variance. Setback from Sand Pond Road from the center line 40 feet, and from Dermody Lane center line 50 feet. This is in order to construct a 24 by 30 24 by 30, 2-bedroom, 1-level, single-family home. Okay, this hearing is, okay, this meeting tonight is, rescheduled from the November 20th meeting. The board had conducted 2 previous meetings, on the application. The site walk, which is on October 26th, and the second for the review for completion of the application on October 30th. All of the seated board members here attended all of those meetings, so they are qualified to vote tonight. The board is made up of 5 members. One member is not here this evening, but did not attend all of the meetings, so would not be voting. For the 5 members, a quorum would be 3. We have 4, so we have authority to vote on it tonight. The board members attending the meeting on October 30th, Lori Downing was nice enough to make up the minutes of the meeting. So I'd like to hear a motion. If all the board members have your copy, you've read the minutes, can we vote on accepting that? Can I hear a motion?
Make a motion to accept the meeting. Second.
Those in favor? Okay, so let the record show that the board accepted the minutes from the previous meeting. Okay, so I mentioned about everybody having an opportunity to speak, and where I'd like to proceed with this is first, we will hear from the party who initiated the appeal, which would be the Marsilios or their attorney or whatever. After that, we will hear from the code enforcement officer, then other parties, and we have a couple letters to read from residents who aren't here tonight. So, would you folks or your attorney like to?
I believe Mr. Moore, our attorney, is going to start the procedure.
Say again?
Mr. Moore, our attorney, I believe, is going to start.
Okay. All right. So, Mr. Moore, are you ready to? Let me say one other thing. Is the board? You all received a copy that Mr. Moran provided us, which from the appeal and some supporting information. You all had an opportunity to review that?
Yep.
Okay. You good with that? So, is that what you're going to base your presentation on, Mr. Moran?
Yes, I've got the package that I submitted to you. First of all, can you hear me all right?
It's just Fred's eye, we can, yeah.
Can everyone hear?
Can you hear? Okay, yes.
Right. So obviously I want to thank everyone for letting me participate remotely given the situation with not wanting to get the rest of you sick. So I appreciate the accommodation allowing us to do this without having to postpone the meeting. Yes, for my presentation tonight, I'm going to be referring several times to some of the documents in the appeal that are tabbed. So I'll be able to point you to some of those documents while we're talking. For the record, I did want to mention one thing. There was some discussion about the administrative appeal being moot. I think there was also some mention in the minutes. I believe that the discussion that we had was it would be mooted by the variance if it were in fact granted. I didn't necessarily agree that it was completely moot. I thought that it was, we wanted to preserve it for judicial review, and then obviously if the variance wasn't granted, then I wanted to have that dealt with. However, we did agree that it certainly made a ton of sense to table
The only thing that I'd like to speak to that on is the fact, and we were talking about it being moved, is when you did the remediation, items that you were asking that we override the previous code enforcement officer, and, in the interim, those issues that he brought up got adjusted. So I was of the belief that was the reason you were looking at them as being moved.
Well, I think that, for sure, the notice of violation that was issued to the Marciellos, that would be moved by the fact that everything was removed. I think if we get into the issue of, like, the legal doctrines of, like, estoppel or vested rights or those things, that's where I would say it wouldn't necessarily be moved. But I absolutely agree that the notice of violation, was taken care of, and I'll explain, why they did that and how they did that to the town's satisfaction. So, I just want to start off by just, I think the overall theme of this, what I'm trying to present, with what I submitted to you, was that the Marciellos are the good people who follow the rules here, and I think that if you look at what we went through over the last couple of years, almost, with this, you'll see throughout the process how they really, went out of their way to try to work with the town and try to do, what was correct. And they found themselves in a rather difficult situation now, that really wasn't of their own making. And we think that the town right now is in a position to help, and should help by the granting of this variance, which, as the Chairman Neal described, is two setbacks that we're looking for variances from, one from Dermody Lane of 50 feet, and then the other one from Sand Pond Road of 40 feet. To go back and just provide some background on this, you really have to start back in 1968 when this subdivision was created. It was an 18-lot subdivision by Milton Garland. And this is in tab 7 of your tab 5 of your package, and our lot is number 12, which is highlighted. You'll see that it's kind of it's a little bit narrower than some of the others, which starts getting into some of the variance factors that we talked about. It's tapered. It's more triangular than some of the other lots. The Garland sold lot 12 and actually lot 8 across the street at the same time to the McNamara's. That was in 1968. At the time, this subdivision had been approved by the Board of Selectmen in Town of Baldwin. They also put deed covenants in there that called for basically the building of houses. There really wasn't much else you could build on these properties. There was no commercial use. You couldn't even put a garage on there unless it was pertinent to the house that was on the law. So those deed covenants you can see are actually in the chain of deeds, which begins at tab 7. They're listed in there. Now these deed covenants have expired, but the only reason I pointed out was to show that, back then, the intent or the understanding all along was that this was going to be a housing development, and that houses would be put on each of these lots. The McNamara's, they sold lot 8. They sold that in 1971, and they kept lot 12. All right. And they kept it till the end, which was basically when the town foreclosed on it and paid taxes. That occurred through a series of tax liens that were filed starting in 2016 through 2019. That's basically when the town ended up taking title to it. So for all that time, that property was vacant. The town tax lien forecloses, and Wayne and Jamie Fuller buy it in 2021. The town at that point gave them, and all these deeds are in that same tab 7, tab 7 that I'm going for. So when Fuller buys it, the town gives them what would typically happen in a tax sale, They give him just a release deed, you know, by his map and lot number. And then Fuller takes the steps, that will be necessary to make the property basically more valuable. A town tax title is no good in terms of, marketability. You usually have to wait at least 5 years before it's cleared up, and I think back then the law was even longer. So he started taking steps to try to correct that. One, it looks like he approached the town to get another deed. So the town gave him another deed in addition to the one he had, the color corrective deed. And this one describes it by map and law number, not map and law number, but a subdivision lot number, which aids in selling it. I mean, certainly it helps in terms of marketability to have that now described by a subdivision lot number, because that's a good description to have. The other thing that Fuller did was he approached the former owner, and got a release deed from the former owner, McNamara, for his widow. And so now he's got a piece of property that's got marketable title. It's not relying just on tax title, he's secured that. And then he takes the next step of getting the permits for the property. So he's taking care of the title. He now goes and gets the permits for the property. In order to do that, he holds a septic permit, a growth permit, a driveway permit, and a building permit. And this was three code enforcement officers ago. This was a code enforcement officer, Wes Sunderland. So Mr. Sunderland actually met with him out at the property and took measurements himself and determined that this was a buildable lot, a grandfathered buildable lot. There's a reference to that in tab 8, which is actually the Marciello's permit, but at the beginning of it you can see a letter that was signed by J. Wesley Sunderland, which basically describes how Wayne Fuller purchases foreclosed lot by the town. The lot is ordinance ruled as buildable since its grandfather. This setback measures can be obtained from line boundaries. It says the required dimensions are 75 feet from the center line, front road, 30 feet from the rear line center of K Lane, which I believe is Demonte Lane, and 10 feet from both side boundaries. He says the above dimensions were measured and examined by West Sunderland CEO and found to be adequate to allow a residential structure of at least 600 square feet to be erected within the setback requirements. And then he also made some findings regarding that back road, which is Demonte Lane, basically saying I don't have to apply the road setback requirement to that would be the rear lot line setback, because it's a private road and it only serves one house. But I think it doesn't function as the road form, it's just basically his rules. Not sure exactly where that came up, because I think the rear setback that we saw in the ordinance was 25 feet, but he ruled that it was 30 feet. But that was how Fuller ended up getting building permits. He got a building permit for the property. Fuller does not end up building on the property. Instead, what he does is he markets it for sale. It gets marketed as for sale with permits in hand. And so the Marciello's then buy. That occurred in 2022, okay, September 30th, 2022. And they paid full market price for a buildable lot, $50,000 in 2022. So they paid full market price based on good title and having building permits in hand for the property. Before that sale, their broker, you get a letter in the file I gave you at the last meeting. She actually went out there with Wes Sunderland again, and he showed the measurements of where the house could be built as well. After the Marciellos buy the property, they make a plan to put the home on the lot. They end up contracting with someone to put a modular home, and they knew it was going to be a small building envelope. They set up some meetings with the code enforcement officer. Actually, at this point now, Don Kent, and they started those discussions in December of 2022. So on tab 10 of the submission that I gave you, these are all of the email exchanges between the Marciellos and the code office, running up until, from December of 2022 until July of 2023, at which point that's when the stop work order had gone into effect and things started turning into more of a legal dispute that basically gave rise to this appeal.
So can I interrupt you and ask you a question?
Yes.
On the application of the permit, it's talking about, it gives a lot size, and it's talking about a single-family, two-bedroom home. The information here talks about the modular home being purchased. How many rooms was that? How many bedrooms in that home?
I believe that was a two-bedroom home, but I'll have to have them.
It's two bedroom, the plans are also included.
It's a two-bedroom home.
Correct.
Okay, so one of the, if some of the emails back and forth between you and Don were talking about a three-bedroom. He said, well, if you do the three-bedroom, then the septic system needs to be upgraded because it's only for a two-bedroom. And then he circled, or you circled, somebody came back and said, well, the modular home has a porch. And Don goes, no, because so I was just asking about this whole thing. When it was purchased, it was a two-bedroom, so you just didn't know it was going to come with a porch on it.
No, we had asked, because our contractor wanted to know about the step restriction, and before we ordered the home, whether or not, if it was steps or if it had a little overhang, if that would account for a porch. So we had asked Don, does this count for a porch, or can we have a porch?
Because I know he did say something about you might be able to
Yeah.
put something on the back, or,
Yeah.
so he was trying to work with you on that.
Just to be on the safe side, we just had the steps because we didn't want to go against any issues, and it's only a two-bedroom home, and the final plans are included.
Right. Okay, Mr. Morris, sorry to interrupt you, I just needed that clarified for me.
No, absolutely. So, if you go back through what happened then, fairly early on, this was basically in March, one of the builders starts asking, well, I don't know if this could meet setback requirements. And so the Marciellos emailed Dawn, and they basically relayed this information that the builder's saying, hey, maybe this can't meet the setback requirements. They were asking if there was a variance recorded, et cetera. And at first, Dawn was saying, well, that could be a problem. Maybe I'll deny it, and you bring an appeal, a variance appeal. The Marciellos actually prepared an appeal. They actually prepared the submission, filled it all out, and signed it, and gave it to Mr. Ken. That was in March, and he said he would get it to the right folks, etc. Then he contacted them again, and he says that actually, he goes, I got another solution. He said that there's no standing appeals board, no appeals needed here. I'll give you the permit. It's going to be 75 feet from San Juan Road, 30 feet from Demone. He's basically saying he's going to rely on what was before. The Marciellos get back to him again. They're saying, well, here's a sketch from our broker, our builder. We're still wondering, does this meet those? It doesn't look like it might meet those setbacks. March 15th, he responded, I can give you a permit, provided the square feet doesn't exceed 720 feet. So they decided to go ahead. They ordered the home, which was about $220,000. They moved forward to get the septic permit in their name. They get a new growth permit. They submitted a new building application. That was on May 10th. Sketch from the builders showing it's only about 50 feet from the edge of Champagne Road. He emailed back saying it looks like everything's fine, and he signs the permit. Well, then, later on, it looks like on the sketch, he wrote 75 feet on the sketch not what they submitted, he wrote it on there when he signed it. It wasn't on the permit, but he wrote it on the sketch. But either way, from the Marcellus perspective, they thought, oh great, we're good to go, we don't need the variance. That's what they understood. They staked it out, the property, the footings got poured and he inspected those, so everything was fine. July of 2020, that's when, some of the issues started happening. The first had to do with, a missed inspection on the foundation, for the foundation.
Excuse me, can I just interrupt you just a second? So,
Yeah.
I have these drawings in front of me. One that has no markings on it whatsoever, and I think in talking with Don, because he had a few concerns back when Wes did what he did, and so I think he was trying to clarify that, saying that, yes, based on what the previous code enforcement officer did, I would do that, predicated on the fact that it would meet setback. And that's, well, you can't see that, but I can see it. This is the original without any writing on it, and this is the one that Don, and he was basically doing that to cover himself, saying, I don't know about this, but because the previous code enforcement officer did it, then I guess I'll approve that. So, and then the other thing, and I'm not being real critical of this, you know, believe me, hindsight 20/20 vision, but looking at some of the emails, Ms. Marsilio asked Dawn back in March, does the town have a survey? No, the town doesn't have a survey because of quitclaim deed, and it looks like, you know, the can being kicked down the road. And then finally we reach a point where, rather than in the beginning coming in and getting the lot saying it looks like a substandard lot, might need to go before the appeals board to see if the setback and so on and so forth. 8 months later, we have a survey done, and lo and behold, guess what? The setback rears its ugly head. So, I just don't want Dawn thrown underneath the bus, because I think reading some of these emails back and forth in the very beginning between the missus and him, it was very cordial, even right up until the wheels fell off the vehicle and the contractor did what he did. There's an email here someplace from Dawn saying how nice it is to work with a contractor. So how do you go from here to here? Something happened, and I'm not blaming them, because if they're in Massachusetts and the contractor's up here, but that's why we came up with the stop work order, because things are out of control.
Well, I can tell you this, Marcellus has nothing to do with any of this. As you can probably tell, you've had a chance to meet him a couple times now. They have nothing to do with any, you know, personal disputes between the Canterbury Homes and the code officer. Matter of fact, they were trying to stop it, you know, they were trying to jump ahead of all that, to really stop that, as you can tell from some of these emails. So, I mean, these are not people who are seeking out confrontation, and every step they're really trying to do what they need to do. With regards to the whole survey issue, I mean, certainly, I'll admit, you know, having a survey at the beginning of this thing would have been great, but not everyone gets a survey. Most people, I mean, often doesn't have one on a property like this. And they're not always held, I cited one of the cases in there, but you're not held to these are the people who are just doing the best they can, right? They're trying to work with the town. Do I need a variance? No. You know, do I need this? They're kind of relying on, you know, some advice that they're getting from the town, the builder, etc. So they're not held to the standard of an expert, I would say, in terms of whether they got the survey. It's still, even if they had, it wouldn't change the fact that, you know, I still think the property qualifies, you know, for variance under these circumstances. What I'm trying to basically explain here is the fact that they didn't have a survey at the beginning should not disqualify them from getting a variance on the wall.
No, and absolutely, I'm not being critical. I'm just saying, if I spend $220,000 for a modular home to put on a lot, I want to know, do I own the land that I want to put the $220,000 modular home on. I mean, that's just how I think. And that's back when we were talking about this administrative appeal and having a conversation with David, and I said, David, I don't see how in good conscience I can assign the board to come up and, nobody knows what's going on here. Nobody knows what are we supposed to rule on. If we don't know what the boundaries are, and are they exceeding this or that, and it just seemed like they wanted to bypass the code enforcement officer and get a ruling from us. I didn't feel comfortable with that, so.
Well, but then I guess the good news is we don't have to deal with that right now. I mean, I think that if we can get a variance and that those issues would basically go away. I mean, I would say, you know, I think if we look at the record, I do think that it can show that these people were relying, you know, kind of in good faith on what they were hearing. And it's true, not everyone gets a survey every time, you know, it just doesn't happen all the time. I mean, I've dealt with many a real estate transaction with no survey. They get a title search, and in this case, though, let's not forget, they also had a building permit. When they had, not only did they have a title search, but when they bought the property, they already had a building permit. Where the CEO actually visited the property and said, this is where you can build. So their reliance on that, I would argue, is something to take into consideration. And let's not, and on the undue hardship part of the test, it talks about whether the hardship was created by them. The way the lot was created certainly wasn't created by our people. It was done, you know.
Excuse me, can I interrupt you just a moment?
Yeah.
We have a budding property owner that is raising his hand. Yes, Joe, did you want?
Yeah, Joe Pierce, I am an abutting property owner, and if you're talking about the quality of the surveys, I would have to point out that the first survey that was done, I guess you'd say I forced them to correct. It was an incorrect survey. I just want that out there.
No, I believe, Mr. Moore, you and I spoke when we first met down at the lot, and I was asking, looking at the survey, I said, just so we can look at this and so I have a sense. I think you mentioned to me that was the third survey. Is that correct? The one that we were looking at in your report here?
Well, I had a number of them done. All right, so I had a number of them done, trying to show where the existing foundation was. There was a bunch of those things. I think what Mr. Pierce is referring to is we had a survey trying to show where the potential line, the center line of Sam Pond Road was when it was laid out in 68, all right? Not where it goes on the face of the earth, but where it was laid out in 68. And then Mr. Eaton had assumed a 3-rod width and put it out further. And Mr. Pierce's surveyor, Butcherumian, said no, he showed some other reasons why it wasn't. So we just basically agreed with his line, put it where it is.
Okay, so he'd like to respond to that.
We don't have a battle over surveys.
I believe we could tell where the road was in 1968, and it was laid out well before 1968. But I believe we could tell where it was by looking at the stumps that are still there. And they're large enough so they didn't grow up from 1960-something. The survey was incorrect and pushed the road over towards my land, and the road, according to the survey, would have been over these stumps that are 10, 12 inches in diameter. You don't do that in 10 years.
I can tell you here, they weren't trying to grab anyone's land. We basically switched it and agreed with Mr. Pierce's surveyor's line to get this in front of the board and get it done. So then we tried to just take that issue off the table. We'll agree to his line of where Sam Pond Road is, and that would, hopefully that put that issue to rest.
Okay.
So there was, we go back to, where things went after that. Basically, there was that, missed inspection, the Marciellos were going to, do something to try to redo the inspection. There was a dispute over the type of construction, honeycomb construction, the height of the wall, there's a bunch of things going back and forth. Apparently some words between him and the builder, had to do with what's required of the ordinance, what's not. Again, the Marciellos are sort of playing a game of telephone here, they're hearing it from both sides, trying to, mediate, trying to, get this thing resolved, literally like pleading, to try to, get things back on track, have a meeting or a phone call. It ended up being a request that, I don't know what happened, but it ended up being that they would have to come in and be recorded in the office with law enforcement present. I mean, it ended up really, going beyond anything they expected.
Well, I think with the contractor, I just think is a situation where he was between a rock and a hard place. I think Don, being due diligent, being there, watching the site, knowing that what we're trying to do is put an envelope on a stamp, not a stamp on an envelope, and they thought the communication lines were working, and the man looking at the lines and where they are, talking to Marcelios, knowing what they wanted, there's no way he could give them what they wanted unless he did expand the lot. And as he started doing what he did, and when, this is all hearsay, so shouldn't even drop the conversation. We need to deal with this here. But it's unfortunate that all the drama happened when what we needed to do in the very beginning is come to the appeals board and look for a variance. And here we are now, so.
Yes. Well, we can talk, and then, it's in the written submissions, but I did want to let you guys know that, one of the delays from getting this in front of you was, town wanted, the code office wanted everything removed. And my client disagreed with that, and we considered whether to pursue some sort of legal things to try to prevent that from happening, but in the end, we decided, and they decided, basically, they didn't want to fight that. Again, I think this goes to show you folks how much they want to work with the town and really want to, get this thing, to a reasonable solution. Some people might have just been like, no, I'm going to fight this thing right through the course right out the bat. No, I mean, they shelled out the money and they dug up the foundation, ripped it out of there, and planted some trees. And Mr. Lee went out and inspected it, said it looks all fine. And Mr. Ken and Mr. Lurie had wanted us to do that even before having the variance. So we did that to get it done with and get it over with, so we could try to get to this issue. And so I just wanted the board to be aware that they did that and got those things, basically yanked everything out of there. So, on the variance now, first, I know you have to vote on each one of the factors, so I just wanted to address them just briefly, so I know we'll have more discussion about them later, but I just want to put in my 2 cents on each one of the factors. First, about the reasonable return. This lot, if we can't get the variance in this case, it won't be buildable, and it won't be able to generate a reasonable return. I did supply you with the letter from the broker basically saying, she couldn't find any comparable values to an unbuildable lot of this size. Not on the water, it's further back between 2 roads. It's not like it has a recreational value on there. Its only probable use would be like a forward sale to an abutter, which I supplied you, the folks, with a case on that basically said that from that would be a reasonable return. So we think that the reasonable return factor has been met. Regarding that the land, the need for the variance is due to unique circumstances of the property, not the general conditions of the neighborhood. A couple different things on that. It is a unique lot compared to the other lots in the subdivision. It's a lot more triangular, which created one of the big problems, especially when we talk about applying the, there's an argument at least that there should be a 75-foot setback on both sides. That basically makes no building lot available, primarily due to that irregular shape. The other things that make it unique, I would argue, is also just some of the steps that the town took over the years, wittingly or unwittingly, that made it, that promoted its, basically its sale or marketability, everything from, the original subdivision plan to the corrected deed to the granting of permits. All those things sort of created this situation where it looked very strongly to the public that this would be something that would be buildable. So those are a couple different things that make this property a little unique compared to some others. The hardship not being the result of action taken by the applicant and the prior owner. Obviously, when it was created, it was legal. The town signed off on it. So Milton Garland didn't create these problems. The fact that the town had also done a bunch of things to, again, sort of assist with its marketability and its building status. Like I said, these things, some of them might not have been intentional, but they did do it. The corrected deed, permits that have been granted. Those, help show that, like, Marcellus, Fullers, et cetera, they weren't necessarily, wasn't hardship that they created. And ultimately, we're talking about the hardship is the setback itself. I also mentioned earlier that these lay people wouldn't necessarily be held to the standard of surveyors. They're going to be, I think a good question asked here is, are these people pursuing things through the proper channels as a good fit? Won't alter the essential character of the locality. Again, this 18-lot subdivision, it's all residential, so this would not alter the locality by having another residence. Again, this would be a very, very small house. And then the final one is that it would be the minimum variance in terms of ordinance as it would relieve the hardship plea. We thought the best way to do this was to propose 40 feet from Sand Pond Road. That's measured from the center line, and that's in our plan, which was, I think that's tab 4. 40 feet from the center line, and then 50 feet from the center line of Dermody Lane. What that does, frankly, is that moves the envelope a little bit further to the west. It gets it a little bit further away from Dermody Lane. One of the issues that they had put up before was that the old foundation was about 3 feet within the 250 feet back from the lake. So this would get that foundation get them out of there. And that would basically create a sufficient building envelope. It's still going to be a tough one because it's triangular, but create a sufficient building envelope to put that little house in there. And so we think that's the simplest and easiest way to do it, again, by getting it a little bit further away from the pond. And I'm assuming, for purpose of this, I'm assuming we need a variance from Dermody Lane, even though the earlier rulings was that it was a 30-foot setback. I'm assuming, might as well, let's consider it 75 feet and let's ask for a variance next, because we're already asking for one from Sand Pond.
So the way the lot is set up and access to the lot would be from Sand Pond Road. Something I read there someplace when the contractor kind of lost it, out there grubbing and digging and going into Dermody Lane, Dermody Lane would not be an access road to the lot. It would be a footpath, correct?
We had offered that earlier on as a solution. We could put some kind of deed covenant saying we wouldn't access off Dermody Lane. I believe that I think the Fuller permit even might have said no driveway on Dermody Lane. I don't think that my clients have a desire or a need for access off of Dermody Lane. I mean, we would like to keep the variance as simple as possible with just step back variance, but certainly I know that the original plan was not to have a driveway on Derby Lane.
Okay.
Was that the plan, Jennifer and Michael?
Yes.
Yeah.
I'm just wondering in terms of us as a board, I know when we went down there and did the site walk, and we were, well, I think, David Laurie had said something about, putting in the variance a pad, and Mr. Stackhouse said he didn't know that he wanted to be, didn't think it was the board's position to do that. And so I'm just wondering in terms of Dermody Lane and the concern, you know, other than just access for the parties that live there on there, if that's something that we would have to write into a variance, rather than wait and see how it played itself out, and specify that it would be access from Sand Pond Road to the lot.
And I know that, I believe it's also a private road, if I'm not mistaken. Is it privately maintained? Maybe some of the audience knows.
Yes, it is.
Yeah, it's privately maintained, so if anyone wanted to join in there, they probably have to help in starting, you know, in maintaining it and everything too. So, I mean, I don't think it's a big deal. I don't think my clients need access off Dermody Lane. I don't speak with them. I haven't really discussed it with them, but if that's a major concern, you know, I don't think that
That's not a concern.
would be a deal breaker for our people.
Okay, no, I just remembered hearing that, and I wondered what you had in your notes.
Yeah, I remember Dermody Lane was private, and I remember I thought there was some discussion about access. I know that I had proposed it at one time. I was like, you know, because of the, you know, what was the road frontage, and I was saying, we'll just close off by deed covenant, any access off Derby Lane. So I had made that proposal at one time to, through your council.
Okay. Does that conclude your presentation, or do you have some more?
It does. I just want to, you know, I want to thank you all and for giving careful consideration of this. I just can't emphasize enough how, you know, this thing could be, situation could be pretty devastating to this young family, 3 young kids, and I know that.
Okay,
You know, I think.
does any of the public have any questions for him at this point? Yes, sir.
So are they intending to use the entrance from Dermody Lane or not?
No.
The answer we got was no, right? The clarification. We just want to make sure that it's clear that the access would not be from Dermody Lane. Are you there, or did we lose you?
Hello, I'm a butter.
No, I was just seeing whether we still had the attorney here or not.
Oh, I'm still here, yeah.
Oh, you're okay. I didn't know whether you had a covert attack
I'm
or
just
something.
wondering if the variance is for a buildable lot for them to sell, or are they gonna put a house there, Marcio's?
At this point, not up for us to decide. You know, we're here to decide the variance. I have some letters here to read, after the code enforcement officer.
Okay.
Unfortunately, some of the information is hearsay. The individual who wrote the letter wasn't even there, it was, so we have a hard time with that, because we weren't there either. And like I said, I tried to make note of the fact that when the wheels fell off the vehicle and whatever, but I'd like to try and keep the drama to a minimum so that we can focus on this. This is what the board's about, so.
And Mr. McNeil, can I just ask, if there's, after other people have any questions, you know, after other people speak too, if I could maybe get a final chance to be able to respond to any of those things, that's been helpful as well.
But his question was, and whether we could get an answer on it, is that, access won't come from Dermody Lane to the lot.
That's correct. I think that Marcel's answered that for me.
Okay, thank you. All right, so now at this point, our code enforcement officer, you've heard up to this point, would you like to address the lot, or?
Well, Mr. Chairman, if the committee has any questions for me, I'm here to answer them, and I'd like to actually make a comment.
Yeah. You want to make the comment before or after?
It doesn't matter, whatever you want me to do.
So, when we were down there, I noticed you were there when we showed up for the sidewalk. And the tape was run.
Correct.
Which was, thank you all for that, because that helps us to have a visual of how it is laid out. To the best of your knowledge, where it is pinned for the foundation, is that how the house was set? Or are there going to be some deviations one way or the other?
I can't say whether there's gonna be deviations, you know, but naturally, this is what when I went down there to work with the folks, this is what we came up with.
So my next question is going to be, I think this is regards to the Dermody property. He had mentioned we were talking about the lot and being able to place a well and a septic tank in there. I think I heard something about his septic system is about 50 feet from where the proposed well for these folks is gonna go. So, do you have enough wiggle room there to make the well and septic go on that lot? To make it work?
I think you do. You can do a number of things today which you never could be prior to. And in reference to if you put in an artesian well, the folks actually usually take a survey or see exactly what's around in reference to the other leach fields. And you've got to actually be so far from them, but you can put in additional casing. And this isn't coming from me, this is basically coming from your well drillers. And also, the additional casing allows you to get a little bit closer to some of the leach fields, whether it's from the adjacent property or whether it's actually on their land. So I don't think that's going to be an issue or a problem. Soil engineer folks can design different systems to meet the demand. It's not just perforated pipe and stone like it used to be. So there's a number of things on the technology side whereby these folks can design a system. And if you've got a wet area, a lot of times they can come up to the above the wet area in reference to designing the system, bringing fill in and things like that. And especially in shoreland zoning, there's been a lot of technology that's occurred over the last 10 years to allow folks to put a capacity system, in a small area with enviro systems and things of that nature. So I don't see where that's gonna be an issue, Mr. Chairman.
Okay, and, I guess my final question would be, in the notes there, emails or whatever, the previous code enforcement officer mentioned that, because of the water table, the location, that perhaps a pad rather than a foundation might be the answer. But that didn't happen, and 1.5 foot down digging, what happened, happened. So, the old saying, once burned, twice learned. Are we gonna try and dig another hole and hope the water went someplace else so it won't be in the foundation? Or are you gonna recommend a pad? What is your plans for that?
Well, I usually leave that up to the folks that do this for a living. And naturally, I don't know where the water table is.
Soil scientists or whatever?
Well, when they actually design a system and stuff, if you see that the elevation reference point on normal systems is like 50 feet down, coming up from the bottom of the bed up, and it's 30 feet, 30 inches or whatever the case might be, with the elevation reference point, you probably have figured out that, they know exactly where the water table is and where it comes up. And they've got to get above that in order to have the system actually function properly.
Okay.
So I can't, in other words, I can't actually give you any insight other than what I just told you.
Okay. Does anybody in the audience have a question for the code enforcement officer?
Yes, how much, fill do you allow to bring in to meet those requirements to get it up out of the water level?
Yeah, when a system is designed, it's actually.
Talking yards of fill?
What's that?
How many yards of fill is allowed to be brought in?
Well, I'm not sure I quite understand your
Well, we're
question.
talking about building up the land to get above the water table. How much would you allow to bring in? They've already brought in a couple hundred yards.
Yeah, it's not
Fill.
what I allow, it's what the soils engineer designs the system to do. So in other words, when
Also
you,
changes the,
well, when you look at a soil, in other words, you look at the design of a septic design in reference to how much fill they're bringing in. On the second page, you get to what they call the elevation reference point. Well, based on what that says will determine the excavator how much fill he's gonna bring in. So I can't answer that willy-nilly, unless I've got a plan in front of me. Which would list pretty much, and a lot has to do with not just the water table, but what type of soil is there. Do you have clay? Do you have sand? Do you have gravel?
it was peat,
What,
brought in gravel. Sand,
you mean peat moss?
yeah, like, there was all woods there.
Yeah,
And they chopped all the trees down and they tore it all up. They took out truckloads of peat fill that was there, and they brought in gravel,
yeah.
and they disturbed the whole ground there.
Why is that an issue?
It's an issue because it sends the water onto my property across the street. And
So you're saying
the water
what
that
they
comes off-
did
Okay,
sent the water over to your land?
yes, and also,
Yeah.
all the
And
water.
I can't even address that because I'm not qualified to do that.
And I have another question too about the survey. When they say they're gonna go 50 feet from Germany and 40 from Sand Pond, those strings they put up, I went through my tape on there, and the measurements are nowhere near 24, 32. You need a professional surveyor to put those points in there and have the proper setbacks. That's my concern.
So we question, after all of this, the third survey, we question that third survey validity, right? Is that what you're saying?
No, when we did the site walk, they put pins in, and I was across the street, I see them slinging the tape around, and then I went out and measured the pins, and they weren't even close to 22 feet by 32.
You mean
They were
the
off.
stakes?
So, I don't know,
Can I respond to that?
it's just willy-nilly, like you said.
Good.
Okay.
Yeah, I was just gonna say, the surveyor drew the envelope, you know, and then he plopped in 24 by 30, a house in that envelope. You know, it could move within that envelope, you know, I don't think we need to specify exactly where the house, because, you know, it could go that way or that way.
Well, you're asking for footage. You're
So
asking-
we just need a setback variance so we can have an envelope where we can put the house in there. The other thing was, I would point out part of that work that we did, I think was to, dig out a swale or something like that. So
Yeah, but-
there was a concern about, erosion. We had a guy, we hired, actually, Mr. Council's familiar with it, but Mike Morris from DEP, former DEP, he's now a land use consultant. We hired him to come up with a plan for, doing the, replanning and all that stuff. And we presented it to the town and they agreed with it. So, that was one of the things we did, before we got here to this appeal. I just wanted to make sure the board was aware of that. We used someone who used to work with DEP to design this plan, that we implemented. It was signed off by the town.
Can I just get your name,
Yeah, Kevin Baroni?
Kevin Baroni, and you're in a butter?
Yes.
Okay. I have a question.
Yeah. All right, so we have a question for you. Hold on a second. Go ahead and-
So, well, I have two questions, for Mr. Kent. One is, I was looking at the permit, I know that a lot of the,
I'm not Mr.
No,
Kent.
I'm sorry,
Yeah.
I'm sorry, you're right, you're not Mr.
Did
Kent.
you want to talk to Brad?
No.
Don't worry, I'm not. Yeah.
Sorry, Mike,
Yeah, that's
I'm
okay. No,
thinking
no,
about
no.
Don Kent.
Look
and
at,
Tony.
I have those moments now too.
I have many of those moments. So,
Yeah.
I'm
So I
looking
understand.
I'm looking at the permit that was granted, and
Yeah.
it's, and it's not dated or signed, but I'm assuming there is a signed copy. I know that a lot of this argument was about, that started, all of this, you know, fighting over the foundation, was whether or not it was a slab, or it should be built up higher, but on the permit, under foundation, it's checked off at 8 feet, not as slab. And I think Don was, or Mr. Kent was claiming in the emails that he had said,
He suggested that in the beginning, and I think, looking at this, you know, whether you take this literally or not, and I know there are issues and problems going on, but if somebody in their mindset, without asking, if you decide to have an 8-foot foundation up in the air in an area where you've got camps and cottages, if your home is set down by Portland headlight, probably no problem whatsoever, because it's all gonna blend in with high stuff. But when you're trying to come into camps and cottage areas, you wanna try and keep it, so to ask the question, does that 8 feet mean 8 feet to the sky, or is it 4 feet down and 4 feet up? I don't know that you ever got the clarification on that until all of a sudden he put up and stopped work on it, because
but it's just,
it wasn't realistic for the area.
but it's just confusing.
It is, and that needs to say 4 feet under, 4 feet above, no, you know, and they were trying to solve their problem with the water table. That's why they were going up rather than down.
Right, so there was confusion.
signed off on
Pardon me?
The 8 foot was signed off on by the
Yeah.
code enforcement
Yeah.
officer.
Yeah.
Okay.
And I guess my other question, and I don't know if you can answer this, Mr. Lee, but,
Thank you.
what was the reason that the permit was pulled exactly?
I can't answer
No,
that.
I figured.
Yeah, one thing I can't do is I can't go back, and dig up old bones with what another code enforcement officer did. I will tell you this, when the permit was actually pulled and the stop work order was issued, the normal procedure that a code enforcement officer should follow in reference to revocation of a permit was not followed. I will tell you that. And you need to give the folks due diligence in reference to come up with a solution if I decide to issue a citation. You can't just decide you're gonna revoke the permit and not have solutions. The solutions would be that before the permit got issued, you may want to look at variances. So I can't answer what the prior code enforcement officer did, and I can't second guess him whatsoever on that, and I wouldn't dare do that. Okay. Mr. Chairman, do you have any other questions for me from the committee?
No, the only thing, and like I said,
I'd like to make a comment then.
yes, let me just finish.
Yep.
The last, I tried to find a note in here and it doesn't tell me. I'm not justifying it, I'm not condoning it, but I think, when Mr. Kemp was in and seeing what he saw, I think he was exasperated. The cutting of the foliage, or brushes, or whatever, on other people's property, the foundation happening, conveniently or inconveniently, trying to get the dates set when he's supposed to go down and inspect, and now it's already there. The fact that the fellow puts his fist in his face and says, this will happen, is not conducive to good working relationship with the code enforcement officer and the resident. So, I read the manual that says what we're supposed to do. Before you do that, you're supposed to have a public hearing, so on and so forth, and then decide whether you put up the stop work order or whatever. Maybe the rules and regulations say that when you got the fire, you're supposed to use a red fire hose. Don used a blue fire hose, he put the fire out. And here we are, so that's why I don't wanna get into all of this stuff, because there's so much baggage going with it. All we wanna do is address the setback. But yes, go ahead and make your statement.
Yeah, that's what I was gonna say. Address, in other words, address the setback and on both sides from Dermody and Sand Pond. I hope you folks actually look at doing that, approving the variance from both sides, only because I think we gotta put this behind us. And it seems like, the town, there's a lot of things that went on, and we have an opportunity to make this right. And then what I can do is I can go ahead and do my job and do my due diligence if you do approve the variance from on both sides. And I'm just saying, I hope you folks do that.
Is that it?
That's it, Mr. Chairman.
I have one more question.
Do you wanna ask him another question?
Well, I'm not sure if this question
Well,
would
this-
go to.
He's Mr. Lee, he's not Don, Don is not here.
I know.
Okay.
I'm never gonna know that, yeah.
All right.
I'm not sure if this question would be for you, Mr. Lee, or for Mr. Moran. Am I getting it right? But I suppose it's for Mr. Moran, because he talked about this concept of equitable estoppel. And I think I'm saying that right.
Yep.
And I read his description in his brief about what that means, but because I'm not a lawyer, and I don't know how many lawyers are here, I'd like to hear that explained one more time, if that would be okay.
I'd rather not bring it up. I think at this point, it's just some more baggage that goes on, and I would rebut that I think when, we're not in court, we're not making a decision. I think when you're doing that, it's almost as if, the sun's shining, the birds singing, everybody's out there, Mary Poppins comes walking through, and then all of a sudden mean old Dawn comes in, the big bad wolf, and shuts everything down. I don't think that's what he was doing. I think he was exasperated at the conditions of what was going on. So this is if everybody was in agreement, we're all fine, and he decides to come in and throw a wrench into the gears. So if the thing wound up going to court and they were to do that, everybody would present their information. But that's basically what it's saying, is you've got to give it to them, you've got to let them have it, because they were doing it in good faith. I don't think the contractor was doing it in good faith. I think he was between a rock and a hard place.
But it's not about what the contractor was doing. That's not,
He's
that's
representing
why,
them.
that's why I
He's
would like,
representing them.
that's why I would like to hear the legal definition.
As one of the lawyers in the room,
Yes.
Jim Katsikas from Perkins Thompson, and I'm here tonight advising the Board of Appeals. Equitable estoppel, we could talk about it and what it means, but we hope we don't have to get there. In the sense of, that's an argument that would be raised if a variance is denied and they have to go forward. The issue tonight is not the good faith of any of the parties necessarily, although I think Marciellos have presented their material this evening in good faith. The question is, are they entitled to a variance? Do they meet the 4 standards for a variance under Maine law and under the ordinance for the town of Baldwin? And then, if they get the variance, we can deal with the foundation issues, the drainage issues. The code enforcement officer is able to look at all that. What happened, happened. We're here about the variance tonight, whether they meet the 4 standards. And I think if we stick to that, then the board will get where it needs to go.
Yeah.
Mr. Chairman, I'd like to mention, just to remind you in the committee, that usually falls under the administrative appeal, and you basically waive that. So in other words, I think it's null and void. Just to make you aware of it.
Yep.
I'd like to add a comment to what Kevin said.
Can you give your name, please?
Pat Merritt. When they got the original permit, all the land and stuff was untouched. But then they came in and they dug up everything, and there was piles and piles and piles of dirt. When the stop order came in and they removed everything, they removed that dirt that was originally there. And now it's sand. It's not any of it that was there prior. So to me, that should change the permit from being tested, whether it was passed for septic, water, or whatever.
So I have 2 letters here to read. The first one, dated January 10th, in an envelope with a stamp on it, return address, but it was physically given to the administrative assistant, Robin. Dated January 10th, it's from Kevin and Deborah Baroni, 8 Germany Lane. Their mailing address is 5 South Monroe Road in North Bill Ripper, Massachusetts. Received on January 13th. Dear members of the Zoning Board of Appeal, I'm writing to express my strong opposition to granting a setback variance for the property owned by the Marsilio family. While I sympathize with the Marsilio family situation, I believe granting a variance would be a mistake for the following reasons. Number one, precedence for future applications. Following a variance set as a dangerous precedence for future applications. It could encourage others to discard zoning requirements and fail to adequately follow the necessary procedures, knowing they may be able to circumvent this regulations by simply requesting a variance. Number two, failure to meet setback requirements. The Marsilio family's request for a variance falls short of the requirement set back by the significant amount, such as variance would be a substantial deviation from the established regulations, which are in place to maintain consistent and fair development across the town. Approving this variance would weaken the integrity of the zoning laws. Responsibility of the property owner. While I sympathize with the Marsilio family's current predicament, I must point out that they are largely responsible for this issue. The problem arose due to the failure to have the property properly surveyed before construction, which resulted in an encroachment of setback. Furthermore, they do not notify the code enforcement officer of work beginning, nor did they adhere to the code enforcement officer request for documentation or compliance. This oversight have contributed significantly to the current situation. I understand the zoning board faces difficult decisions, but I respectfully urge you to consider the long-term impact of granting such a variance. Our community's zoning laws exist to preserve the integrity and orderly development of Baldwin, and any deviation to these standards could potentially undermine these efforts. Thank you for your time and consideration, and I trust that you will make the decision that's best for the town and its residents. Signed, Kevin and Deborah Baroni. This one was hand-carried and given to Devin Wakefield January 27th. It's from Patricia and Ernest Merritt, Jr. My wife and I have been in East Baldwin for almost 50 years, seasonal and permanent. We live at 65 Sand Pond Road in sight of the lot in question. We know when it comes up for bid, hoping one of the abutters would win. We watched the trees disappear, and our amazement, they cleared everything on both road sides of the lot, opening it up so the abutters had no privacy at all. At the time, the lot had standing water most of the time. It did not appear to be a buildable lot, and we were surprised to see a permit on the tree. Later on, we found out it did not adhere to the building permit. So we feel that all the trouble that we have put the town and CEO through, they don't deserve a variance. Also, the lot was not adequate to begin with. We've opened up the property so that they have opened up the property so that one abutter lost almost all of his privacy. They didn't consider the neighbors at all in the building process. Furthermore, I understand they don't want to live there. They just want to unload it onto someone else. I'm putting this in letter because I don't want to upset neighbors who is a friend of mine. So anyways, you probably have upset them. Sincerely, Patricia and Ernest Merritt, Jr. And as I say, unfortunately with some of this, as you're reading down through it, it's hearsay. If they didn't physically see it themselves, they can be empathetic of somebody, but this isn't something that the board should do. So, based on that I've read, does anybody else have some input they'd like to?
Yes, I do.
Yes, sir.
I live across Sand Pond.
Give me your name, please?
Stephen Conquest. I live on White's Lane. I'm pretty much engaged in the politics that go on around the pond and all that. I know most everybody. I've been here for 27 years. I haven't seen much clarity, and to sit here and listen to this and try to make a subjective
decision as a townsperson. I think it's premature of anything to go down the road tonight at all, based on the facts of what I've heard, and what I've tried to learn. As far as I'm concerned, I still think there's a lot of legwork to be done, if anything, to move forward with this as a taxpayer or a resident. Listening to all this it's confusing, technically confusing. I know you guys are gonna make the ultimate decision. I feel for them. I understand about their financial loss. But his letter was well put. That was word. As far as I'm concerned, that's something I would have said. I think there has to be some type of precedent held against the town and against the building inspector and the developer. There was a lot of oversight. There was a lot of people, a lot of assumption going on. And to sit back and try to sit here and make a subjective decision as a taxpayer with a side with you, which I agree in some aspects, I don't think it's justifiable at this point. There's too much confusion. We haven't been told. Are they selling a lot? No one has said anything to me. I went to that site walk. No one said anything that they were planning on turning the property over or anything. I wasn't told. That affects my decision and how I feel. There hasn't been a lot of clarity on that. I feel for what he said about Sand Pond Road. That's a big deal. If anything, that's probably one of the main decisions. That needs to be figured out. We just can't guess at something like this. Like he said, it's going to affect the whole town. And there's going to be other developments that are going to try the same thing.
Well, I think what the board is trying to do, you know, is the fee objective and look at the lot itself. We're trying to look at the lot itself. We have no idea what their plans or intentions are. But if they wind up turning around and selling the property, the next person in line, you still need to have it clarified. You need to know, is it they're going to be able to build something on it, or is it going to be a vacant lot?
That's the point, yeah.
That's where we're at.
Correct.
Clarity on it. Yes, ma'am.
Gail Walsh for Jackson Land Trust land near it. But, I just wanted to know, I'm a little confused as well. What is the exact variance that you're talking about? Is it 40 feet from Sand Pond Road? Does that mean Sand Pond Road, public road changes or moves? Because that was mentioned, I thought, at the meeting. As well as what is the variance of 50 yards or whatever else you're talking about? Because I don't understand the basic concept that you need to vote on, to be honest. With the Germany Lane and the Sand Pond Road, there was mention of taking, you know, land away. Oh yeah, well, yeah, we have to do that. That is not okay for any situation, no matter who they are or what they've been through. So, can you just clarify what the variance is? Because we have no reference. We have no picture besides the ropes that we saw at the walk.
Well, I'll try to, and if somebody else decides to step in to clarify for me, I'm more than happy. But in a perfect world, in where we have 2 acres now, minimum lot size, because we came up with zoning, and with setbacks, front and side setbacks, but now we have a lot that was grandfathered, and so is it a buildable lot? So what you, in my mind's eye, when you're looking at the variance, you're making allowances for the fact with a 2 acre lot, you've got to comply with this distance and that distance. The variance is telling them no, that you can actually encroach or go either way, 40 feet or 50 feet, so that you can put your house in the middle of the lot. That's, if somebody else want to jump in at any point, go ahead. But that's what I take from
What
it.
is the grandfather part of this? Is this their grandfather when they sell it? Does that still apply?
Yes.
That,
Yes, according to the ordinance, yes.
Okay.
As long as that lot was a buildable lot at one point, it was before this ordinance was put in place, and it remains a buildable lot.
But at some point, does that involve them?
It doesn't, it says in our ordinance, it doesn't matter if it's transferred or not.
I mean, we had to expand every lot we had to 2 acres. So I mean, back in the 1990s, we didn't have 2-acre lots on Jackson Lane for both houses. So we expanded our lots to be 2 acres. And now you're saying it
You have the
doesn't
luxury of
matter.
having that extra land to do that. That problem is they don't have any extra land to do that.
So it says here
Right,
in the
so-
ordinance, a non-conforming lot may be built upon, provided that such lot is in separate ownership and not contiguous to any other lot in the same ownership, and that all provisions of this ordinance, except lot size and, road frontage, can be met. So if somebody has a lot that's not 2 acres, and they wanna build on it, and they also own contiguous land to it, or they will need to expand their lot in order to make it conforming. When you don't have that option, you don't have that option.
So you can't build, isn't it that simple?
No, what that means, and this is as the town's, as the board's attorney, a non-conforming lot, and lot 12 is a non-conforming lot in an approved subdivision, may be built upon, provided that such lot is in separate ownership and not contiguous with any other lot. The Marciolos don't have any other land adjoining it. This is their lot. It's about a half acre. You couldn't approve it today, but it was created in 1968 before zoning, and so you can build upon it under this ordinance adopted by the town meeting, so long as it meets all other lot requirements of the ordinance except lot size and road frontage. And so the problem is that the frontage isn't met from San Juan Road and from Germany Road, and that's the reason for the variance. And if you get a variance, if you get a building permit, if you get any kind of permit to build something on a lot, that permit runs with the land. I can sell it tomorrow, I can sell it 30 years from now. So whether somebody may or may not sell the property really isn't relevant. The question is, does this meet the objective standards in the ordinance for a variance?
That's excellent clarity. I really appreciate all that. Thank you.
So the only other thing that I wanted to mention or bring up as part of, we're trying to wrap this thing up, is that July 13, 2021, the town of Baldwin tax-acquired property for sale by bid. At that time, when they were bidding it off, there were 3 parcels of property. The one at the bottom is map 14, lot 33, 0.45 acres, less than an acre, for $5,000. Unless I'm misspeaking, I talked to one of the select board members recently, and there were no abutting property owners who put in a bid
I put it, yeah, we did.
for this property.
Yeah, we did.
You did? Okay, so when you put in the bid,
And Tom did.
was everybody bidding $5,000?
No. We didn't.
Okay. So there was an interest in obtaining the property, it's just that you didn't win the bid.
Right.
Fuller outbid us.
I just needed that clarified, whether now it's coming up as an issue, when you had an opportunity to buy it then.
Very next day, Fuller and West Sutherland were out there in the pouring rain, running a tape measure on the lot to see if it was conforming. And apparently, something happened, and he passed, West said, yeah, I guess it's buildable if it meets the setbacks. And that's how he got a permit. That's what I understand.
Okay.
Just one last thought, is the question was, what is the request here? How many feet and what? And what are we all talking about? And I'm going to ask Mr. Moran, Attorney Moran, if he agrees with this, just so I can, make sure we're all on the same page. With the application for the variance was a boundary survey of lot 12, Milton Garland Sand Contract Subdivision. It was prepared by R.W. Eaton Associates. It's dated, November 17, 2023, with the latest revision date of, September 9 of 2024. So that was submitted to the board, and on that, it shows a 40-foot setback from the center point of the historical location of Sand Pond Road, as I understand it, and a 50-foot setback from the center line of Dermody Lane. I think everybody recognizes that the frontage of this lot, where it gets its access, and that's frontage under the ordinance, is on Sand Pond Road. And so that's where you would normally have a 75-foot setback. But instead, the setback is proposed as 40 feet from the historic center line of Sand Pond Road. And that the setback... The traveled way, excuse me. The traveled way of Sand Pond Road, as shown on this survey. Is that correct?
Correct.
So it's 40 feet, as shown on this survey. It's 50 feet from Dermody Lane, as shown on this survey. And that's what the request is for a setback to those lines.
Yes.
Does that answer your question about what the variance is?
And it doesn't alter the road or anybody's property line to do that?
No.
There's no change in or impingement or whatever on, thank you very much.
The property is shaped like a piece of pizza. And when you put a square rectangular house on it, the frontage is gonna change as it goes down the length of the house because of the pizza shape. So it could be 50 feet, 10 feet from Al's property, but it could be only 30 feet from the Dermody Lane, the center of Dermody Lane. So
Aren't you
have to
talking
look at
about
it.
the center of the road, like, the center of the road is 40 from the center of the road, not someone's property line, right? 50 and 40,
Yeah,
okay.
but they're looking to go 10 feet off the property line, off of Al's property, 10 feet over, and they're saying it's gonna be 50 feet from the center of Dermody Lane.
Right.
And it's pizza shaped, so as you go down the foundation,
Okay.
if it's a 30-foot foundation, 30 foot down the road, it could only be, 30 foot frontage.
I see what you mean, okay.
So it's something that needs to be
Light
scoped out.
bulbs. I like light bulbs.
Okay, and all I would say is just a suggestion, it's me, not that I'm the chairman, just as an individual, is the saying that, good fences make good neighbors. Whoever winds up with the property, and knowing that you're getting setbacks and wherever, at some point, I think a nice attractive fencing to let everybody know, I'm on this side, and you're on this side, and hopefully someplace down the road, somebody could share a cup of coffee or a donut, and maybe could kind of mend some of the things that's happened to the community as a result of this, but, that's just me, that's how I am. Okay, so does anybody else in the public have anything they would like to say? Want to give you an opportunity? Because if not, we're going to close that part of the meeting. There we go, yeah.
I just wanna ask the Marciellos, is this property for sale now?
I believe you, heard my attorney's answer on
Is that a yes or no?
You probably wouldn't have asked if you heard it.
that. I'm sorry, repeat the question, please, sir?
Is this property for sale?
No.
No.
It's not on the market, right?
Okay, so you wanna get it as a
Doesn't matter to us.
buildable lot before you sell it. All right. I'm just curious, and I wanna buy it.
So if the public comment is ended, then it would be appropriate to hear a rebuttal statement from the Marciello's attorney.
Okay.
Yeah, I'm just, trying to wind this up, folks, so,
Can he speak?
yes.
Can he speak, the attorney?
Can he speak?
Yeah.
Yes, go ahead.
Just briefly, on the letters, I believe one of them was from Mr. Barone, so I just want to clarify. And I don't know about the second one, if that was also someone in the audience, but it wasn't an additional person, it was someone who had already spoken at today's meeting. With regard, and I guess the only other, briefly, two points here. I don't think that this will set a bad precedent if you grant this, because there's already some pretty rigorous standards, built into, granting a variance that, the legislature wrote it so that you could allow some sort of, flexibility or accommodation, which we believe is appropriate in this situation. And then finally, we don't believe that the current situation is, confusing. We're simply asking for the setback variance. And what that will do really, it's not confusing because it'll just allow, the completion of this, building, which the town has basically approved already twice. The difference will be, it will be moved, now we'll have a very defined building envelope. That will be a little less certainty. I would say it definitely, removes some uncertainty that might have been before. And, it will move a little bit further away from the lake, which was one of the requests that we got earlier in this process. So I think that'll increase certainty and it will decrease any confusion. And again, thank you very much for your consideration of this matter.
Absolutely. I'd like to, just put a thank you out to, both Bob Flint and, to, Robin Anderson, our assistant, for making this all happen tonight, because I did not want to have to try and postpone it again. So, I hope you're on the mend and, we get through this.
Better today.
All right, thank you. So, like I said, at this point, we've had the public comment.
Do you want a motion to close the public, do you want a motion to close the public hearing?
Yes. So we need.
I make the motion that we, close the public hearing.
Second.
Those in favor? Okay, let the record show that unanimous, 4 board members during the public hearing. Okay, so what I'd like to have you two is come over to this table, bring your chairs and come over to this table.
He's dreaming, right?
Somebody else. Well, I've been accused of that before too.
Well, you could.
Well, actually, you can just sit there like that and deliberate. That's not a problem. You don't have to make.
I'll bring a chair before you.
You want to sit there and we'll pull our chairs over there?
Go for it.
I just find that, if we're trying to deliberate, I'd rather look at you and have us back and forth.
Public hearing, we go to the
Well, the public will hear. And they'll have to speak loudly enough that the public can hear.
Thank you, John.
Yeah.
So, can our attorney present remind us, do we first make a motion, or?
How you usually do it, there are the 4 standards for a variance that the applicant has to meet.
Yeah.
You've heard discussion.
I've got that here.
You've got that right here.
She just wanted to.
And you take a vote on each one.
On each one.
And in order to get a variance, in order to grant a variance, all 4 have to be met.
Okay.
And so the first one is, whether the land in question cannot yield a reasonable return unless a variance is granted. So if you want to start there, maybe,
No, I don't.
You don't start?
No.
I don't?
No.
Okay.
All right. Okay. So the first one I have, the Board of Appeals notice of decision of variance. This has to do with the, application of administrative appeal, stop work order, and notice of violation. I would like to make a motion, based on the lack of information provided and the written, suggestion by both attorneys that we override or bypass or ignore the administrative appeal. That would be the reason for denying it. Do I hear a motion on that?
You're saying rather than table,
At this
Number
point,
one,
we are,
yes,
number
yes.
one, we have tabled, and now we're acting on the administrative appeal part.
We voted already to bypass earlier in the
We
meeting.
haven't, we have to sign this.
Well, we can incorporate that into a notice of decision at the end.
We have to sign this. Everybody has to sign it. So my thought was, we have this one
That we've
that
already
we
voted
addressed.
on. You want to,
They have to get something in the mail that tells them how we handle this part.
Within 7 days after making a decision, the Board of Appeals has to issue a written notice of decision.
So after we act on this, after we do something, then we're going to address this part.
I've
Setback.
prepared a draft decision to help you folks, if you'd like, and we can work through it. But what it notes is that the stop work order is moved, and the NOV has been satisfied, the notice of violation. I think you've already made the motion, so that just addressing it in your written decision would be enough. I've got that prepared and can.
So we don't sign this. What I was doing, we don't sign two of them, we're gonna,
I'm gonna draft one, and the board's going to authorize you to sign it, and I'll get it out to you tomorrow, so that you can sign that along with a certificate of variance, if that's what you decide to grant, because they need to record that in the registry if you grant it.
all right. So I was trying to address that part, but it appears that
We'll help you.
we've kicked the can down the road, it's gone again, so, all right. All right, so the Board of Appeals, notice of decision of variance, for a minimum variance. 73 San Juan Road, East Baltimore, Maine. And it says, the applicant has demonstrated legal interest in the subject property by providing a copy of the deed. We have a copy of the deed in our manual.
so do we want to, I'm trying to find, here we go. Do we want to go through each hardship?
We're gonna, yes, don't get ahead of me.
Okay,
All right. So the applicant has proposed the following building structure, use of activity on the subject property. 24 by 30, 2-bedroom, 1-level, single-family house. We're in agreement with that. The applicant seeks a variance from the following dimensional standards. Minimum variance, 40 feet from San Juan Road and 50 feet from setback from Dermody Lane to construct a 24 by 30, 1-level, 2-bedroom, single-family home on map 14, lot 33A.
I would be careful with that. It's from the center line of Dermody Lane, and it's from the center line of the traveled way of San Juan Road, because that's, your order is going to be recorded in the registry, and people are going to be acting on that. So the setback that's requested is 40 feet from the center line of the traveled way of San Juan Road. That's why I put together the draft findings.
Okay, center line from...
Of the traveled way of San Juan Road.
Okay. Yeah.
And 50 feet from the center line of Dermody Lane, and we'll say as shown by the RWE survey, boundary survey. That's where it shows these.
By what survey?
RWE Associates.
Surveyors out of West.
And it's their boundary survey.
Okay.
Is that the survey that I agreed to?
I believe so. I'll show it to you because this is what I have.
Okay, so number 12, the land is being used as proposed single-family home site.
The dates.
13.
It's hard to read.
So you look at this.
The conditions and character of the neighborhood are
Over the center line.
seasonal cottages and permanent year-round homes.
You see what I mean?
14, the conditions of the property are rural district.
The center line.
15,
I don't know what your legal.
the applicant has requested the following type of variance. A, undue hardship, dimensional variance, which I would say that's what they're looking for. And D, which is setback variance for single-family dwelling. 16, on January 29, 2025, the Board of Appeals conducted a public hearing on the application for a variance. The board also met on October 30th, 2024, and October 26th, 2024, to deliberate on the application, to prepare findings of fact and conclusions of law. Additional facts, other facts relevant to ordinance criteria. Grandfather's lot before minimum lot size zoning was established. Okay, based on the facts stated above, if the reasons for following, the board concludes that undue hardship, dimensional variance, the applicant has or has not shown that strict application of ordinance to the applicant and to the applicant's property would cause undue hardship. The public, what are your feelings on that? Create an undue hardship for them?
Well, that's the ultimate decision,
Yeah.
that you first find for the four, on each of the four standards before you vote whether.
Okay. So, the land in question can or cannot yield a reasonable return unless the variance is granted.
Well, that seems to be the case. I can't imagine anybody paying $50,000 for it right now with not buildable.
If it couldn't be built, no, I would agree.
Why is it that you think it's unbuildable? Because you can conclude that the land can't yield a reasonable return on a variance, but what's the basis for it? I think what was suggested is that the triangular shape and its narrow width of the building envelope on this awkward property can't accommodate a reasonable sized building, such as the 24 by 30 requested by applicants, without a variance of front and rear setbacks. Would that be the reasoning for it?
Well, yeah.
Well, there was also a letter submitted by a realtor saying that you wouldn't be able to get $50,000 if you didn't have a building permit.
So, based on the configuration.
Not even big enough for a pot farm.
Yeah. Based on the configuration of the lot. I mean, I'm happy if we have the attorney here for advice.
Sure.
If he wants to give us the wording.
Yeah,
then
I make a motion with the wording that the attorney just, be in the final document. Sounds good.
Okay, so it's gonna be on record and whatever, so.
So it would be that the board would motion that the lot cannot yield a reasonable return absent the variance, since the triangular shape and narrow width of the building envelope on this awkwardly configured property cannot accommodate a reasonably proportioned dwelling, such as applicant's proposed 24 by 30 foot home structure, and the possibility of a sale to an abutter essentially would be a forced sale, and so isn't a reasonable alternative. Is that the motion?
But you only have 3 lines here. Are you gonna work all of that in?
Well, I'm gonna work some magic. I'll incorporate yours into a draft, and we'll put it all together in one document. You'll see tomorrow.
Yeah, that sounds good.
That was my motion, right?
It was right
Just
there.
what he
What
said.
he said, can we make that motion?
And who's the second on this? I'm sorry.
I think I was.
Second.
Okay.
For those in favor? So we're passing the baton to the attorney. Okay. The need for variance is or is not due to unique circumstances of the property and is or is not due to the general condition in the neighborhood. And I would say yes, it is.
And that's because it's triangular and it's between two waves?
Yeah,
Is that,
basically what you just said previously, same reason.
Yeah,
so the motion might be that the Board of Appeals concludes that the applicants meet this standard of unique circumstances, since it's the unique circumstances of the property resulting from its triangular shape and location between two waves that create its difficulty in meeting the rural district setbacks.
You gonna move that, Keith?
Yes, I move what he just said.
And I'll second that.
those in favor? Okay. The granting of a variance will or will not alter the essential character of the locality.
No.
Number three.
Showing the hardship is not the result.
What's going on here?
Grant- Granting of,
Different from, okay,
okay.
yeah.
So essentially, we're not altering the character of the locality by granting it. It's basically
It's a residential area.
camps and cottages.
And that many of the cottages don't meet the 75 foot.
The fact, yeah, because of adopting zoning, all of those who are there are hard pressed to meet the requirements.
Yeah.
So a motion might be, the Board of Appeals concludes that the applicants meet the standard of not altering the essential character of the locality, since a grant of the requested variance would permit the applicants to construct a dwelling structure in a neighborhood of residential uses and houses built in an approved residential subdivision. The proposed structure and use are consistent with the essential character of the locality, and many existing cottages do not meet the setback, the front setback.
Mine does.
Make a motion?
Is that true or false on that?
It's true.
Okay.
So, did you say most do not meet, what was?
You say several
Several.
existing cottages do not meet
Okay.
the front setback, is that a true statement from your?
No? All
The
the,
front setback is on the pond, not on the street.
oh, for that side. So are there any cottages that don't meet the
Not that I
setback?
know of.
Then we'll just leave that off, and simply say the proposed structure and use are consistent with the essential character of locality. Is that the motion?
Yes, that's the motion.
I'll second.
Those in favor? Okay, D, the hardship is or is not the result of action taken by the applicant or prior owner. You have to say yes, it's not a result of action that they've taken it. Correct. Pre-existing.
Yeah.
Right. So it meets that criteria. I don't know how you say that.
So, given what you said about a lot of record earlier, would you perhaps, the board move that the hardship is not the result of an action taken by the applicant or a prior owner, because the property, is a lot in an approved subdivision, and so implicitly was created as a buildable lot. The property therefore is considered a non-conforming lot of record under section 5.2A of the land use ordinance, so that it would be buildable despite changes in road frontage and minimum lot area since 1968, so long as it meets all other LUO standards. And further, at least 2 code enforcement officers issued letter opinions and building and other permits in 2021, 2022, and 2023 for location of a dwelling on the property. And so the applicants had no reason to believe the property was not a buildable lot when they acquired it in September of 2022, or that the front and rear setbacks posed an obstacle to building on it. Is that true? Is that what you find, what you believe, what you conclude?
I would say yes.
That was my thinking.
Those in favor?
Wait, I just
I'll
wanna
read back
hear,
up.
what did you say about the you do say it's non-conforming because it was established in 1968?
That's correct.
Okay, just wanna make sure that was in there.
So is that a motion?
I make that motion?
Second?
Those in favor?
So then ultimately, the question is, do you find that they have shown undue hardship and are, and grant a variance to, permit construction of the proposed 24 by 30-foot dwelling with a front setback of 40 feet from the center line of Sand Pond Road, and I would say from the center line of the traveled way of Sand Pond Road, to make sure we're all on the same page.
Can you give the dimensions of the dwelling again?
24 by 30, is that correct?
Yeah.
That's,
I thought you said 36.
No, 24 by 30.
Yep.
Their proposed 24-foot by 30-foot dwelling with a front setback of 40 feet from the center line of the traveled way of Sand Pond Road, and a rear setback of 50 feet from the center line of Dermody Lane, both as shown on the R.W. Eaton boundary survey. That's the motion. Do you grant that variance?
Yeah.
We need a motion. I'll move that motion.
To grant that variance, okay. And the second is?
John Bishop.
And vote. Could there also be a motion to, do you usually all sign the decision, or no?
No, we have.
Could you, in this instance, could you move to authorize the chair to sign this notice, sign the notice of decision, incorporating the findings and the conclusions that you have approved tonight?
I make a motion that we designate the chair to sign the, what is it called?
Findings of fact and conclusions of law, incorporating the conclusions and findings you've made tonight.
Incorporating the conclusions and findings we made tonight.
Second.
Laurie seconds it. You're so off.
Yes.
Blow on it, and there you go.
I will get that written out, you'll get it tomorrow, I'll send it to Robin, and she can get that to you. There'll also be a separate certificate of variance that you'll need to sign and give to the Marciellos and their attorney. They will have to report it within 90 days or else the variance will not be valid.
Okay. All right, so we basically completed the application for variance. Appreciate the public input, appreciate the civility that has actually taken place here this evening, and I'll be careful going home, because there could be some black ice out there.
Good job, Joe.
I guess the meeting is adjourned.
I'm going to stick another. I'm out of here. I got it.